Well, we're joined now by the immigration lawyer, Ivon Sampson, to tell us his take on the bill. Ivon, morning. We've talked to you about this before. Morning. People like Brendan Clark-Smith and Lee Anderson, what they want to do is prevent any individual appeals. If the decision is to deport someone, that's it, no appeals. They've got a point, haven't they? Because lawyers like you, with all respect, are often, aren't you, bringing in appeals automatically to delay the entire process.
Well, let me put it, it's not possible. The process to put a general ban on every single individual case is not lawful, not so long as while we're in the Refugee Convention. You'll remember that the bill, what it says is that, generally speaking, Rwanda's safe. That having been said, you've got to consider individual circumstances, compelling reasons, compassionate reasons for an individual. For example, someone could have a mental illness and they may well impact on their safety in Rwanda, despite the fact the government saying that it's safe. Now, the courts back in December didn't accept assurances by the Rwandan government that it was safe. They didn't accept assurances by the UK government that it was safe. And what the government's doing now is saying, right, we're going to declare it safe by an act of parliament. And in my view, Rwanda is not a safe country. Paul Kagame has a history of extrajudicial arbitration, extrajudicial killings, putting down his opponents, putting them in jail. That's a sort of person that we're dealing with. So by simply having an act of parliament to say, well, we say it's safe, there's going to be a conflict with the courts when it gets back to the courts.
But, Ivon, what about the suggestion that lawyers are deliberately clogging up the system with appeals, multiple appeals, again and again, knowing that they're just dragging out the process? That's what these Tory MPs are trying to stop.
Well, put yourself in an asylum seeker's position. Someone's trying to remove you to Rwanda. There's a law which allows you to make an application to Strasbourg to prevent it. What would you do, Andrew? You say, you know what, I'm not going to do it because I don't want to clog the system.
Well, I'd cut Strasbourg out. That's what I do.
The law as it stands gives them the right to do that. So if you want to change it, you've got to come out the convention. There's no other way. And I'm afraid that Robert Jenrick understands that it won't work. Now, the bill also has a caveat for ministers to override the decision, an interim injunction by Strasbourg. Even if they do that, I think you'll get challenges in the High Court for judicial review of that decision. Because if there's compelling reasons as to why the injunction was granted, it begs the question, why would a minister override it? So that also has to be lawful. It's not done. I don't think the courts will get through with this before the election.
Ivon, talk me through the real-world application of this. This clause, which basically means that that appeals could be made. Give me the certain circumstances in which those individuals could claim that they can't go through this process of non-refoulement that we heard. What kind of situation might they be able to claim under the way the bill is at the moment?
Well, I'll give you an example. So somebody could say they've got a mental illness and they have a doctor's letter, a report to say they cannot be sent to Rwanda. That will be compelling reasons to stop that person being removed. Now, what their argument would be that they won't feel safe because of their particular individual circumstances. Look, you cannot in law have a blanket ban. It's unlawful, it's inequitable, and it's not fair process.
That feels like a very low bar. If it's just a letter from a doctor to say, I've got a mental illness, that could be claimed by anybody, given I have such anxiety, I can't get on the aeroplane. I'm claustrophobic, I can't get on the aeroplane. Like, is the bar genuinely that low?
It's actually the opposite. The bar's very, very, very high.
Oh.
And the government's done that because they're going to have to get an expert to make an assessment and make those findings. If it's not genuine, no expert's going to do it. So the bar's actually quite high. It's the exact opposite.
OK. All right.
That's the lawyer, Ivon Sampson. Always a joy to talk to you, Ivon.